Swayam Prabha. Digital India. Educated India.
Hello friends, I am here in the 15th session under the course The Law Relating to Women and Children. In earlier lecture, I focused on dowry provision laws. In the present session, the topic of the lecture is Law Protecting Women's Health Rights. The concerns about the health of women is also very important area, and these concerns becomes relevant because of the fact that women, they constitute almost half of the population of our country. Not only of our country, but half population of the world. They have a very important role to play in the society. The women are the creatures of life. They are not only the creatures of life, but they are the creature of the future generations. Women are the creature of life. Women are the creature of future generations. The women, they are the managers at home, and they are the managers of our families. Therefore, they are also called as homemakers. They are not only managing the affairs of home and family. In addition to this, they are the makers of home and family. It means that they make the family, they make the home, and without the sound health, they cannot play this important role. The women are the first teacher of a child. As we have already discussed in earlier lectures, the children are the asset of any country or any nation. The children are the future human resource of the country, and therefore, the making of the children becomes very significant for the development of any country, for the development of any nation. Women are the first teacher of the children, first teacher of the child, and they are teaching the child, they are making the child at such stage of life of the child when the child is susceptible to learn anything, and this is the age of the child when the foundation of all the future learning is made. That means that women are the makers of the future generations of the country. They are the makers of, they are the creature of the future human resource of any country, and therefore, it becomes relevant to have the concerns about the health rights of the women and to protect the women against any kind of such activities which affect the rights of the health rights of the women or the health conditions of the women adversely. What is the international mandate about the protection of the women's health rights? What are the national actions or initiatives in India for the protection of the health rights of the women? This is the subject matter of the present lecture. As to the introduction at very outset of the lecture, we will deal with the introductory discussion over the health rights of women. Women, as I have already told you, that women comprise of nearly half of the population, and their relevance in the society is unparalleled. we can understand how the relevance of the women, how the role of the women in the society is unmatched, it is unparalleled, because they are doing the work in the society in different roles, in the role of mother in making the child, in the role of housemaker in making the house and the family, in the role of the social reformer when they are teaching the ethics, the morals to the children, and as a contributor to the national development when they are doing the work as a workforce of any country or as the human resource of any country. Taking care of women health is important for society building. There is the direct connection between the building of the society or society building and the conditions of the health of women, and therefore taking care of women, it directly relates to the society building, as the women are the creature of life and coming generations. To draw focus on the plight and needs of women, International Women Day is celebrated on 8 March every year. If we see the theme for 2024 International Women's Day, that is our voices, our actions, our demand, uphold women's health and rights now. So, the focus of 2024 International Women's Day was our voices, our actions, our demand, uphold women's health and rights now. This focus was on the women's health and the women's rights. As per the report of National Family Health Survey NFHS 5, 57% of women of the reproductive age and 67.1% of the children below the age of 5 in India are anemic. This is very unfortunate that 57% of women of reproductive age, when they need the proper health, the sound health and the strength in their body to give birth to the healthy child, at this stage, at this time, the 50% women of the country are anemic. So, and see the result or consequences of such health condition of women. Because of this health condition of women, 67.1% of children below the age of 5 in India are anemic. This NFHS 5 report suggests that 23% of women not married before attaining the age of majority, got married before attaining the age of majority. This is also the reason for the ill conditions of their health or ill health conditions of the women. 23% women is still in this modern age, when the age of the marriage has been fixed, the personal laws have also been taken into consideration to raise the age of the women, age of the girls to marry. Now, the law has been made and it has been provided by the Indian legislature that there would be no inequality in specifying the age of marriage for boys and girls, and this has been elevated from 18 to 21. Now, both the bride and bridegrooms are required to have the age of 21 to marry. But still 23% of women in India, they got married before attaining the age of majority. Unsafe termination of pregnancies on diagnosis of gender of the fetus is not only discriminatory to females in general, but also jeopardize women's health by multiple abortion. In earlier lecture, I referred to the incidences of female feticide. Female feticide is certainly an offence, a very grave crime, and it is the discrimination on the basis of sex, that the girl child before her own birth is caused dead. And because of this female feticide, the women who carry the child, they undergo multiple abortions, and these multiple abortions certainly affects the health and health rights of the women. There are several factors that govern women health in contemporary India, such as lack of awareness, not being priority of household, financial dependency, early child bearing, malnutrition, inadequate and expensive health care services. All these factors are responsible for ill health conditions or ill health of the women, and therefore, if we want to protect the women's health rights, then it is necessary to address all these factors which are responsible for the violation of infringement of the health rights of women, and these factors of lack of awareness. Lack of awareness in Indian society, particularly when the girl child are not receiving those facilities, are not given those facilities which are provided to the male child in the family for their teaching and learning. They are always far from the new technological inventions and developments. They are always deprived of the access to these new technologies or know these technological inventions, and therefore, the sources of information which are available for all the women or the girl child, they are deprived of these sources of information, and therefore, there is the lack of awareness. Not being priority of households, this is a common social practice which we face, which we see in our families, that the girl child or the female child is not on priority. Either the education of the girl child or the health and nutrition of the girl child, it is not on priority. Who is on the priority? The male child is always on the priority for the purpose of giving the nutritious diet, for the purpose of giving the giving healthy foods, for the purpose of providing the educational facilities, for the purpose of providing different sources of information, and girl child is not on priority. This is also the reason for the lack of awareness. This is also the reason of the non-awareness of or the lack of the knowledge about the rights of the health, about the access, the manner in which the women or the girl child can have the access to these rights. Financial dependency is also one important reason. Normally, we see in families, the women are always dependent on the earnings of their husbands, their fathers or their mothers. They are always dependent for economic needs on their male counterparts, and the male counterparts of the family, they are not giving the priority to the requirements and needs of the women, and this is also the reason for which they are affected health wise or their conditions of health are deteriorated. Early child bearing is also one reason for the bad health of the women. They are married in the early age and they bear the children at this early age. When their body is not capable of, their body is not ready for these biological changes, at that time when the woman bear the child, their health always is affected. Malnutrition, the lack of the nutritious food to be provided to the girl child in the family, lack of the nutritious food for the women in the family, this is also one reason affecting the health and health rights of the women. Inadequate and expensive health care services. Sometimes we see that the family members, the husband of a woman, the father or the male counterpart or the person who is responsible to give the care to the girl child or women in the family, they are ready to provide the health services, but these health services are so costly that they are not in position to provide proper health care services to the women and this is also one reason for affecting the rights of women in India. Now, we are to see that what is the international mandate about the protection of the health rights of women. In 1979, the CEDA was adopted, the Convention on the Elimination of All Forms of Discrimination Against Women. This international instrument under Article 12 mandates the states to deploy appropriate measures to prohibit discrimination against women in respect of health care, especially pregnancy, postnatal care, nutrition, lactation, etc., and ensure equality among men and women in respect to access to health care services and family planning. As I told you that the concerns to the health of women is not the subject of only national legislations, or it is not the concerns of only the countries and nations separately, independently. This is the concern of whole the world, and this concern was realized by the international community, that the health, the protection, non-protection to the health rights of the women or the bad health conditions of the women may affect the development of all the world. And therefore, with this realization, the CEDA, when it was adopted in 1979, included the provision like Article 12, which mandates the states to deploy appropriate measures to prohibit discrimination against women in respect of health care. As I discussed that there is the discrimination in men and women in providing the health care services. This realization was made by the international community, and therefore, the states now are obliged under Article 12. This is the commitment of all the countries which are member to the CEDA, to this convention, that they are to take the appropriate measures to prohibit the discrimination against women in relation to the health care. And especially this health care includes, according to Article 12 of CEDA, the pregnancy, the postnatal care, the nutrition, the lactation, etc. It is also the duty of the states under Article 12 of CEDA that the state parties or the members to this convention are to ensure equality among men and women in respect to access to health care services and family planning. This is also one important reason for the bad health of the women. Whenever there is a question of family planning, then the male counterparts, they are never ready to undergo the sterilization operations. They always prefer the women to go under these sterilization activities, which changes the hormonal secretion in the body of the woman, which is contrary to the health of a woman, and this is also the reason for the bad health conditions. And therefore, the international community through Article 12 of CEDA mandates the state parties to stop any kind of discrimination in relation to the family planning, in relation to the health care services, in relation to the nutrition, in relation to all other things which are responsible for the bad health of the women. The International Convention on Economic, Social and Cultural Rights 1996. We know that International Covenant on Economic, Social and Cultural Rights 1996 was adopted. There are separate kinds or generations of human rights. In the area of human rights, we say that there are several generations: first generation human rights, second generation human rights, third generation human rights. Nowadays, there is the discussion over the fourth generation human rights also. The social, cultural and economic, cultural and educational rights are considered to be the second generation human rights. In 1996, when this International Covenant on Economic, Social and Cultural Right was adopted, that was the time of the realization of the international community with respect to or in relation to the guarantee of social, economic, educational and cultural right, that is the recognition of the second generation human rights. Under Article 12, it is urged that states to recognize everyone's right to recognize everyone's right to enjoy highest standard of physical and mental health, with special focus on including stillbirth rate and infant mortality rate, development of child, access to medical care and services. It means when everyone has the right to enjoy highest standard of physical and mental health, when this Article 12 is read with Article 12 of CEDA, it means that everyone has the right to enjoy highest standard of physical and mental health, and there shall be no discrimination in men and women in this regard. The special focus has been made on reducing stillbirth, reducing the stillbirth rate and infant mortality rate, development of child and access to the medical care and services. Then comes Convention on the Rights of the Child 1989. This international instrument under Article 23 provides for states' action to secure rehabilitation, education and appropriate steps to ensure physical and mental well-being of disabled child, and to empower the parents with adequate information, financial and institutional aid and preventive health care. This Article 23 focuses on the state action to secure rehabilitation, education and appropriate steps to ensure physical and mental well-being of disabled child. Disabled child may include both the male child and female child, and therefore, this Article 23 also relates to the rights of women or the rights of female with regard to their health or their health rights. When the state parties are to ensure the rehabilitation of disabled child, the education of disabled child and appropriate steps to ensure physical and mental well-being, not only the physical health, but also mental health is also the subject matter of Article 23 of CRC. Article 24 provides member states are to recognize right of each child of highest attainable standard of health to consecutively lower infant and child mortality rate, ensure accessible medical services, tackle malnutrition, negative environmental effects, prenatal and postnatal care of mothers, sanitation, hygiene and family planning. Article 23 of CEDA was relating to the disabled child, including disabled female child. Article 24 relates to the health rights of all the child. It provides that states are to recognize right of each child of highest attainable standard of health, including prenatal and postnatal care. It is directly relating to the health rights of women. When we talk about the prenatal and postnatal care of mothers, then it has the direct bearing on the health rights, the protection of the health rights of women. Family planning is also responsible for the bad health or non-enjoyment of the health rights of women. So, the family planning, the postnatal care and prenatal care of mothers, these 2 points of Article 24 have the direct bearing on the health rights of women, and all other aspects of Article 24 also relates to the women's health rights, because it is a general article. This is the general provision to include both the male and female child. Then 1948, the Universal Declaration of Human Rights, UDHR. This UDHR as the landmark instrument, international instrument, in its Article 25 recognizes the right of standard of life coupled with health and well-being of one and the family incorporating food, clothing, housing, disability, sickness, social and medical services, motherhood is declared to be entitled to special care and attention. The health rights are recognized for all under UDHR, but the special focus was made to the motherhood, when the motherhood is declared to be entitled to special care and attention. Though all the persons, they have the health rights, they have the right of standard of life coupled with the health and well-being, but the special care should be there to the motherhood for their well-being, mental well-being, or for their physical well-being. After international mandate, after seeing or discussing the international mandate, where we see that in various international documents, in various international agreements or the commitments, there are the concerns about the women's health rights, and state parties are expected, or the state parties are given the responsibility, or they are imposed the duty, obligations to take care of the health rights of women. Now we are to see the provisions of the constitution or the constitutional mandate in India with regard to the health rights, protection of health rights of women, or the protection of women's health rights. If we see the constitutional mandate, it may be found in the form of Article 15(3). I have referred Article 15(3) many times. I think in each and every lecture of this course, the law relating to women and children, I have quoted Article 15(3), I have referred to Article 15(3). We can understand the relevance of this constitutional mandate, because this is the general provision which gives the authority to state to make the affirmative discrimination in favor of women and children, meaning thereby that special legal and administrative measures may be adopted by the state, by the government, for the well-being of the children and women, irrespective of Article 14 and 15 in general. And if such special measures, legislative measures or administrative measures are adopted by the state, that would not be considered to be discriminatory or violative of Article 14 in general and 15 1 and 2, because this authority has been given to the state by the constitution itself. And therefore, Article 15 clause 3 also enables the state to take appropriate legislative, administrative or otherwise policy measures to protect the rights of women with regard to their health or their health rights. Then Article 21 of Indian Constitution. This Article 21 of Indian Constitution is the most significant article which gives or which confers the right on any person, right to life and personal liberty. In many cases, it has been interpreted by the Supreme Court of India that right to life and personal liberty, or the meaning of right to life under Article 21, does not mean only the recognition of the guarantee of mere animal existence. This right to life means right to live with human dignity, and without the healthy conditions, no person can live with dignity. And therefore, Article 21 also plays an important role with regard to the guarantee of health rights of women. In the case of State of Punjab versus Mahendra Singh Chawla, which was decided in 1997 by the Supreme Court, the court held that right to life includes right to health, which later allowed Supreme Court to recognize reproductive health and choice of women as part of right to life in landmark case of Suchita Srivastav versus Chandigarh administration, which was decided in 2010. If we see the approach of the Supreme Court of India in these two cases. In Mahendra Singh Chawla case, the Supreme Court was of the opinion that right to life includes right to health. When right to life includes the right to health, it means the women are entitled to the better conditions for having the sound health. And in the case of Suchita Srivastava, the Supreme Court says that reproductive health and choice of women is the part of right to life and personal liberty. The women cannot be considered only the means of reproduction. The women cannot be considered only the means of fulfilling the sexual desire or the lust of male counterpart or their husbands. The women have the choice for reproductive decisions. The women have the choice of their reproductive health, and they have the choice whether they are to reproduce or not in accordance with their health conditions. And this right has been recognized by the Supreme Court of India under the case of Suchita Srivastava in 2010. Article 39E of Indian Constitution. This is a part of Part 3 of our Constitution, that is the directive principles of state policy. And this Article 39E obliges the state to take policy action in regard to the health and physical strength of men and women workers, along with delicate age of children, is not taken advantage of, and they are not bound by economic necessity to engage in activities that are not warranted as per the health, strength or age of the workers. It is noteworthy that here the especially women is mentioned in the provision. So, that policy should not lack the specific focus on women's health and physical capacity. Article 42 of Indian Constitution, that is also the part of directive principles. It requires the state to formulate provisions to secure just and human conditions for work and for maternity relief. The just and human conditions of work for the women who are working in different employments and maternity relief, these both the issues, the just and human conditions of work and the issue of maternity relief, both directly relates to the protection of health rights. If the proper human conditions or just conditions are not provided for women to work at their workplaces, then certainly their health would be affected adversely. If they are not given the maternity benefit or maternity relief during their pregnancy or after the birth of the child, when they are to devote their time for lactation and otherwise care of the children, then certainly again their health or their health rights would be affected adversely. And therefore, Article 42 also requires the state to have the specific policies for providing the human and just conditions of work for women and for ensuring, for guaranteeing the maternity benefit, which we have discussed in earlier lecture on the maternity benefit or under the labor law relating to women. Article 47. Under Article 47, the duty has been imposed on the state to uplift the nutritional level, standard of living and probe public health. State is also obliged, state is also obliged, this is not state, this is state is also obliged to prohibit the consumption of intoxicating drugs which are injurious to health, with an exception for medical purposes. So, intoxicating drugs are allowed only for the purposes of medical purposes, and otherwise these should not be allowed. State should make such a policy. In pursuance to this constitutional mandate, the Indian legislature takes some legislative initiatives. What are these legislative initiatives? Protecting the health rights of women, we are to see. In 2021, one enactment was passed in the name of the Surrogacy Regulation Act. From last 2 decades, more than 2 decades, we witness a new kind of development in relating to the reproduction or in relation to the worth of children. Traditionally, only the biological mothers, they were considered to give birth to their natural child. But when a woman is not capable of giving the birth to the child because of the health conditions or because of any other kind of infirmity, then only the option of adoption of the child was available. Then the technique of surrogacy started. Any other woman can be agreed to become the surrogate mother for another woman. When this surrogacy, system of surrogacy came into existence, then several issues and concerns were also there regarding the, particularly regarding the rights of the health rights of the woman, because we see in the country like India, where a large section of the society, it is fighting for earning the bread of two times. In such a situation, the surrogacy may not become the medium or the means of earning. Some regulations were made, and finally in 2021, the Surrogacy Regulation Act was enacted. This act allows widow or divorcee women from age 35 to 45 or a married couple who cannot bear children due to some medical condition to gain the child through surrogacy in altruistic manner by some woman who is genetically related to the couple. So, this condition has been imposed that they can take the help of other women for the purpose of surrogacy who is genetically related to the couple. This act under section 38 penalizes commercial surrogacy with imprisonment of 10 years and fine up to rupees 10 lakhs. So, the commercial surrogacy is not allowed in India. Surrogacy is allowed, but the couple can take the help of only genetically related women. In 1971, one enactment was passed, that is Medical Termination of Pregnancy Act. Under the lecture on the topic of dowry provision laws in India, I referred to the situation of multiple abortions because of the menace of female feticide. How these abortions may be regulated? On one hand, under the right to life and personal liberty, a woman has the right either to continue with pregnancy or to give up or to abort it. But in what conditions the abortion should be allowed? This is the question of relevance with regard to the health conditions of or the protection of the rights of the women. Sometimes we see that women are not aborting their child with their own wish, but because of the compulsion or the pressure from their family or husband. And therefore, Medical Termination of Pregnancy Act was enacted in 1971 to take care of or to regulate the matters of abortions, medical terminations. This act allows legal medical termination of pregnancy in a medically authorized manner. In India, classically or traditionally, the medical termination was not allowed. The medical termination is still considered to be the murder of the child in the fetus, and therefore, sometimes even in the bad conditions, it was not allowed. The medical termination, if it is suggested or recommended by the medical practitioner because of the health condition of women should be allowed, and this act allows legal medical termination of pregnancy in a medically authorized manner. After the 2021 amendments in the act, it has become more inclusive and robust in securing reproductive rights of women. Reproductive rights of women are directly related to the health rights of women. Section 3 of this act, as per the latest amendment in 2021, unmarried women and married women both can seek relief under the act up to 20 weeks of gestation period. Up to 20 weeks, the medical termination of pregnancy is allowed, and this is allowed for both married and unmarried women. This time limit exceeds to 24 weeks for rape victim survivors and beyond 24 weeks for substantial fetal abnormalities. So, there are 3 stages of the time period. 3 time limits have been fixed, timelines have been fixed. Generally, the medical termination is allowed up to only 20 weeks of gestation period from the date of the pregnancy up to 20 weeks. This time limit may exceed to 24 weeks if the woman is the rape victim survivor. In this case, this may be 24 weeks, and it may go beyond 24 weeks also if there are the fetal abnormalities. That means that if the child in the fetus is abnormal, then the medical termination of pregnancy may be allowed even after 24 weeks. For reliable medical accountability under section 5, opinion of one registered medical practitioner is required for the termination before 20 weeks. If the termination is made before 20 weeks, then the opinion of one registered medical practitioner is allowed. Opinion of such 2 experts is required for the termination in between 20 to 24 weeks. If the termination is made before the 20 weeks, the opinion of only one medical expert, medical practitioner is required. But if the termination is made after 20 weeks, between the 20 and 24 weeks, then the opinion of 2 medical experts is required, and approval of medical board is mandatory in case of termination after 24 weeks. But if this goes beyond 24 weeks, then the opinion of medical board is required. So, 3 stages of the approval are also there. Within 20 weeks, the approval of the opinion of only one medical expert, beyond 20 weeks, but within 24 weeks, 20 to 24 weeks, the opinion of 2 medical experts, and if it goes beyond 24 weeks, then the approval of medical board is required. Then in 1994, one more enactment was passed in this regard, Preconception and Prenatal Diagnostic Techniques Act. Female foeticide was the social evil, and we faced this female foeticide in India because of various social and economic reasons, and therefore, the Preconception and Prenatal Diagnostic Techniques Act 1994 was enacted, so that the diagnosis of the fetus on the question whether the child in the fetus is male or female could be prohibited. This act was enacted to address the issue of female foeticide. This discriminatory practice not only led to the unequal sex ratio in the country, but also created unsafe medical incidents for pregnant women. Due to pressure from society and families, the act under section 4 prohibits the use of sex selection techniques like ultrasound machines before or after conception. Its use should be restricted to detect genetic or chromosomal abnormalities, metabolic disorders, etc. Why this enactment was enacted in or was made in 1994, not before it? We know the development in the area of computer science The techniques like ultrasound, then color Doppler, these were developed. And because of these new techniques for the diagnosis of pregnancy, it became possible for the medical practitioners to determine the sex of the child in fetus. We know that the development of science and technology also poses some challenges before the society and the country, and these challenges are always addressed by the law, and therefore this law was enacted in 1994 when these techniques began to be misused by the medical practitioners and by the parents, by the husbands and wives or the families or the individuals who are not willing to have the female child. The section 4 prohibits the use of sex selection techniques. So, sex selection techniques were prohibited like ultrasound machines. The ultrasound machines or the color Doppler machines should not be used for the sex selection after conception. Its use should be restricted to detect genetic or chromosomal abnormalities, metabolic disorders, etc. Penal liability is also attached under section 22 of the Act of advertising for any prenatal and preconception sex determination facility in any form with imprisonment for up to 3 years and fine up to rupees 10,000. This fine may be increased because this is very small amount for those who are involved in this crime. So, the penal liability has been imposed for advertising. If any person having the ultrasound machine or having such technique advertises for prenatal and preconception sex determination facility, then he shall be punished with the imprisonment up to 3 years and fine of rupees 10,000. Early child marriage is also one challenge for the women's health rights. As I have already referred to the effect of early marriage or the child marriage on the health of rights because of various reasons. The mental stress is there because in that early age a girl who was in the age of growth, development and taking education, she is involved in the family responsibilities. There is certainly the mental stress on that girl child who is married in early age. On the other hand, the child bearing in early age also poses the challenges to the health of those girl child. This act seeks to prohibit child marriage and make it a penal offence. A child marriage not only take back the opportunity to grow and be a child by burden of marriage, but also leads to early pregnancy, which is very harmful for physical and mental health of the mother. An amendment bill was introduced in 2021 to increase the minimum age of marriage for female to 21 to create equality with male counterpart and diminish the risk of early pregnancy and burdens of marriage at the tender age. Now, the age of marriage for bride has been increased from 18 to 21 and thus the gender equality is maintained. In the law, the age for the girl was 18 and for the bridegroom it was 21. Now, the equality has been maintained and the age for bride and bridegroom both has been fixed as 21 years. The Maternity Benefit Act is also connected directly with the protection of health rights of women. I have discussed this Maternity Benefit Act in relation to the maternity benefit with respect to the rights of women or with respect to the labor law, but this maternity benefit also relates to the health issues of women. The 44, 45 and 46 Indian Labour Conference recommended that maternity benefits to be given to 24 weeks, which led to the 2017 amendment of the Act to increase the maternity benefit from 12 weeks to 26 weeks. Earlier it was 12 weeks, but now after the amendment, the maternity benefit has been increased to the 26 weeks. And it is not available only for the pregnant women, but also up to the 12 weeks of commissioning mothers and adoptive mothers. 24 weeks for all the mothers, all the pregnant women, and 12 weeks for the commissioning mothers and for adoptive mothers. Commissioning mothers means the mothers under the technique of surrogacy, and adoptive mothers means the mothers who become the mother, the woman who becomes the mother after the adoption of the child, by way of the adoption of a child, they are the adoptive mothers. So, this is unique feature of this maternity benefit, that 12 weeks maternity benefit or maternity relief is also being given to the commissioning mothers and to the adoptive mothers. As per section 5 of the Act, this benefit can be availed by women who have worked more than 80 days in the last year in the organization. Organizations have been asked to facilitate work from home for new mothers to provide relief. This provision we have discussed already. Now see the judicial approach with regard to the health rights of the women. What has been the approach or the attitude of the judiciary in India? In the case of X versus Health and Family Welfare Department in the year of 2022, the Supreme Court states every pregnant woman possesses reproductive autonomy that render her the right to choose to continue with the pregnancy or abort it without seeking consent or authorization from someone. Now see, this is very revolutionary approach of the Supreme Court of India, when the Supreme Court says that whether to continue with pregnancy or not, it is the personal decision of the woman concerned, and that woman is not required to take the consent or the permission of anybody, including the husband. In the case of Z versus State of Bihar, which was decided in 2017, the Supreme Court awarded compensation in the case when, due to failure of the government machinery, pregnancy could not be terminated and caused violation of Article 21. So, when the woman wishes, decides, determines to abort the child, to abort the pregnancy, when the woman has determined not to continue with the pregnancy, then it is the duty of the state to guarantee this right. And when there is the failure of the state in this regard, state machinery, then the compensation was awarded. In the case of Suchita Srivastav versus Chandigarh administration in 2010, the Supreme Court says that personal liberty as mentioned in Article 21 embodies right to make reproductive choices for women. In the case of Municipal Corporation of Delhi versus female workers, the relief provided under Maternity Benefit Act 1961 can be availed by women engaged on casual or muster roll basis or on daily wages in the municipal corporation. So, if any woman is employed on daily wages, she can also claim for maternity benefit according to this decision. Parmanand Katara versus Union of India, that is very authoritative case decided by the Supreme Court with relation to right to life and personal liberty, and right to medical aid is the part of right to life and personal liberty. It was held. Paschim Bengal Khetiyar Mazdoor Samit versus State of West Bengal, the Supreme Court held that denial of timely medical care to save life in the government hospital establishment is violation of right to life and personal liberty. In Triple X versus Union of India, 13-year-old rape victim who was 26 weeks pregnant was given relief by Kerala High Court by allowing the termination of pregnancy. In the Acts versus Principal Secretary, Health and Family Welfare, NCT Delhi 2022, the Supreme Court unanimously on deciding the scope of Rule 3B of the medical termination of pregnancy rules decided that rule include the unmarried woman seeking termination of pregnancy due to change in marital status situation between 20 to 24 weeks. In Dobbs versus Jackson, this was the US Supreme Court decision. In this decision, the Roe versus Wade decision was overruled and made termination of pregnancy as illegal, but India, the medical termination of pregnancy is still allowed. Thank you very much.
Hello and welcome to this piece of literary snippet. Perhaps the most popular literary genre after novel is the short story. Sharp, compact narratives whose charm lies not only in what is said but also in what remains unsaid. Today I'll be reading one of the shortest instances of a short story that I have ever encountered, and indeed, the very charm of this particular story that I'm going to read out today lies in the way it abruptly ends. It is an ancient tale from Mesopotamia which has been retold by several authors, among whom the name of Somerset Maugham stands out. The adaptation that I'll be reading out is perhaps the closest to the one that Maugham wrote. The story is titled, in all of its adaptations almost, as Appointment in Samarra. Here is the story. A merchant in Baghdad once sent one of his servants to the market. The servant was supposed to buy provisions for the merchant, but when he returned, he came back empty-handed. Indeed, the servant had all gone white, and trembling with fear, he told his master that he had met death in the marketplace. When I entered the market, the servant said to his master, I was jostled by a woman, and when I turned to look at her, I saw that she was death. I am very scared, master, because death looked at me with a threatening gesture. Can you please lend me your horse so that I can fly away from Baghdad to the town of Samarra and thereby escape death? The master, being a good man, gave his servant his best horse and saw him gallop off to Samarra to escape death. Then the master himself went to the marketplace and confronted death. Why did you make a threatening gesture to my servant? Asked the master to death. And death replied, it was not a threatening gesture. Rather, it was a start of surprise. I was astonished to see your servant here today, because this evening I have an appointment with him in Samarra. See you in the next episode of Literary Snippet.